and welcome all. Today we'll discuss about the very most important question related to the evidence law.
ଆଉ OJS ର आंसर राइटिंग बैच लॉ पेपर विथ इंक्लूडिंग आपनकर इंग्लिश बैच आंसर राइटिंग बैच आपण सेपरेट भी नहीं पारिबे जो माने जॉइन करिया कथा बाहर 50-60 हजार 30 हजार नौचंती आमे तार 5 गुण 10 गुण रु कम पैसा रे प्रोवाइड करिवु जो माने जॉइन करिया कथा बिल्कुल जॉइन करि पारिबे आंसर राइटिंग जे जेते लेखिबो तार सेते डेवलपमेंट हबो आमे आंसर राइटिंग दबु क्वेश्चन दबु खाता चेक करिवु आंसर लेखिक दबु कोन लेखिबो प्लस डिस्कशन भी किछि रखिबु कोन आपण आदरा बेस्ट इनपुट देई परिबे जो माने लॉ पेपर आंसर राइटिंग जॉइन करिया को चाहउछंती बिल्कुल कांटेक्ट करि परिबे.
What do you understand by substantive or adjective law? And in which category would you place the law of evidence? Or else we'll talk about the new Bharatiya Sakshi Adhiniyam, that is 2023 new act which replaces Indian Evidence Act. So the answer to this question lies in two different segments, and I'll teach you how would you put it forth and how would you identify the parts of the question. So the first part lies, what is the difference between, or what do you understand by substantive and adjective laws? So if we talk of the complete body of laws, that is corpus juris, it is divided into two categories. Primarily the substantive laws, which is like the set of rules, regulations that govern the whole country and the society. These laws are written, framed, and they include primarily rights, duties, liabilities, and henceforth are called substantive law. For example, our Indian Penal Code, which is again Bharatiya Nyaya Sanhita, and other laws such as Indian Contract Act, family laws, all are the substantive laws. On the contrary, we have the adjective laws or also the procedural laws. So what are procedural laws? So basically the procedural aspects of the law, which are the set of rules and regulations with dealing with the law, for example, while they are being implemented or executed. So the law of evidence basically neither comes completely under substantive law nor comes completely under procedural law. So henceforth it is majorly a subject matter of adjective laws, which defines pleadings, evidencing, procedures with respect to substantive laws. Okay, so Indian Evidence Act is basically based on English law of evidence, which is not very exhaustive and does not contain the all rules of evidence. The law of evidence is the part of law of procedure with a view of ascertaining individual rights and liabilities in individual cases. So law of evidence is a part of law of procedural laws, which also includes subjective or substantial laws. For example, if we have to ascertain certain rights of individuals, rights and liabilities of individual in particular cases, so the evidence law will help us identify the facts that may and may not be proved. What sort of evidence must be given to a fact which may be proved? Thirdly, by whom and in what manner the evidence must be given by which any fact is proved. So, Evidence Act or our Bharatiya Sakshi Adhiniyam does not define or fix rights or liabilities under the law, but only prescribes for a mode by which rights or liabilities or parties are as curtailed or are as persuaded. It is thus adjective law which helps in proving or implementing the substantive laws. On the contrary, if we talk of substantive laws, which are the laws which act as a machinery, right? Which act as the basic, ideals or principles or rights and duties that are prescribed. And procedural laws, on the contrary, comprises of rules, by which the court hears, determines, and helps what will happen in the proceedings which they prosper or they proceed with. For example, in civil proceedings, how will you put forth the various methods and how are the substantive laws being administered. Similarly, in the criminal or administrative proceedings, there is a set of rules and methods that are designed to ensure a fair and consistent application of due process of laws and how the fundamental justice to all cases are put forth before any particular court of law. So the validity hereby of substantive laws is tried and tested through these procedures, and henceforth the procedural law comes into picture. In the context of procedural laws, the rights may not be exhaustively referring to the rights to information, rights to justice, rights to participate, or general or political rights. Procedural laws are made to ensure the best distribution of our judicial resources. A court cannot impose a civil or a criminal penalty on any individual or any they cannot put any received notice of any case that is being filed against him or her or has not got a fair opportunity to present their evidence or defend themselves. So that standardization, or you can say the basics of the procedural laws depends on how any case is filed, how parties are being informed, how evidence is being presented, and how the facts are determined to maximize the fairness in any legal proceeding. I hope this explains it all. Thank you very much.
जो माने हमर ओजेएस न्यू बैच लास्ट एग्जाम रे हमर 32 क्वालिफाई करथिले आउट ऑफ 55 जो माने जॉइन करया कथा ओजेएस इंग्लिश रो न्यू बैच हमें जनवरी 25 तारिख रो स्टार्ट करछे बिल्कुल जॉइन कर परिबे नंबर स्क्रीन रे स्क्रॉल करछि ओजेएस न्यू बैच जनवरी 25 तारिख आ ओजेएस रो आंसर राइटिंग बैच लॉ पेपर विथ इंक्लूडिंग आपनकर इंग्लिश बैच आंसर राइटिंग बैच आपण सेपरेट भी नहीं पारिबे जो माने जॉइन करया कथा बाहर 50-60 हजार 30 हजार नौचंती आमे तारो 5 गुण 10 गुण रो कम पैसा रे प्रोवाइड करिवु जो माने जॉइन करया कथा बिल्कुल जॉइन करि पारिबे आंसर राइटिंग जे जेते लेखिबो तार सेते डेवलपमेंट हबो आमे आंसर राइटिंग दबु क्वेश्चन दबु खाता चेक करिवु आंसर लेखि दबु कोन लेखिबो प्लस डिस्कशन भी किछि रखिबु कोन आपण आदरा बेस्ट इनपुट देई परिबे जो माने लॉ पेपर आंसर राइटिंग जॉइन करया को चाहउछंती बिल्कुल कांटेक्ट करि परिबे जनवरी 29 तारिख रो हमें स्टार्ट करछे फर्स्ट आंसर राइटिंग सेक्शन